Lecture 3 Sources of International Law Sources Article 38(1) of the Statute of the International Court of Justice is widely recognized as the most authoritative and complete statement as to the sources of international law. It provides that the court, whose function is to decide in accordance with international law such disputes as are submitted to it, shall apply of international conventions, whether general or particular, establishing rules expressly recognized by the contesting states, b. international custom, as evidence of the general practice accepted as law, c. the general principles of law recognized by civilized nations, d. subject to the provisions of Article 59, judicial decisions and the teachings of the most highly qualified publicists of the various nations, as subsidiary means for the determination of rules of law. Although this formulation is technically limited to the sources of international law which the International Court must apply, in fact, since the function of the court is to decide disputes submitted to it in accordance with international law, and since all member states of the United Nations are ipso facto parties to the statute by virtue of Article 93 of the United Nations Charter, states that are non-members of the UN can specifically become parties to the statute of the court. Switzerland was the most obvious example of this until it joined the UN in 2002. There is no serious contention that the provision expresses the universal perception as to the enumeration of sources of international law. Custom. In any primitive society, certain rules of behavior emerge and prescribe what is permitted and what is not. Such rules develop almost subconsciously within the group and are maintained by the members of the group by social pressures and with the aid of various other more tangible implements. They are not, at least in the early stages, written down or codified and survive ultimately because of what can be called an aura of historical legitimacy custom within contemporary legal systems, particularly in the developed world, is relatively cumbersome and unimportant and often of only nostalgic value. In international law, on the other hand, it is a dynamic source of law in the light of the nature of the international system and its lack of centralized government organs. Customary international law has two main constitutive elements. The first is the coincident, permanent practice of the states, objective element, and the second is the opinio juris, subjective element. The objective element of customary international law is the practice of the states. The objective element means the cohesive practice of the states in time and space. The time dimension of customs has a traditional perception that it means if the practice exists more than 99 years ago, the criteria considered is fulfilled. On the other hand, because of the technical and scientific development in some law areas, only a couple of decades are enough to clear the practice of states, such as the space law. The subjective element of the customary international law is the opinio juris. Opinio juris is a belief that following the practice is not just a simple gesture but a real legal obligation. Treaties, in contrast with the process of creating law through custom, treaties or international conventions are a more modern and more deliberate method. Article 38 refers to international conventions, whether general or particular, establishing rules expressly recognized by the contracting states. Treaties are known by a variety of differing names, ranging from conventions, international agreements, pacts generalized charters, through to statutes, declarations, and covenants. All these terms refer to a similar transaction, the creation of written agreements whereby the states participating bind themselves legally to act in a particular way or to set up particular relations between themselves. A series of conditions and arrangements are laid out which the parties oblige themselves to carry out. The obligatory nature of treaties is founded upon the customary international law principle that agreements are binding, pacta sunt servanda. Treaties may be divided into lawmaking treaties, which are intended to have universal or general relevance, and treaty contracts, which which apply only as between two or a small number of states. Such a distinction is intended to reflect the general or local applicability of a particular treaty and the range of obligations imposed. It cannot be regarded as hard and fast, and there are many gray areas of overlap and uncertainty. General principles of law. In any system of law, a situation may very well arise where the court, in considering the case before it, realizes that there is no law covering exactly that point. Neither parliamentary statute nor judicial precedent. In such instances, the judge will proceed to deduce a rule that will be relevant by analogy from already existing rules or directly from the general principles that guide the legal system, whether they be referred to as emanating from justice, equity, or considerations of public policy. Such a situation is perhaps even more likely to arise in international law because of the relative underdevelopment of the system in relation to the needs with which it is faced. The term of recognized by civilized nations means all of the independent states and all of the nations. The general principles of international law, prohibition of the threat or use of force, duty to settle disputes peacefully, duty of non-intervention, duty to cooperate. Judicial decisions, although these are, in the words of Article 38, to be utilized as a subsidiary means for the determination of rules of law rather than as an actual source of law. Judicial decisions can be of immense importance, while by virtue of Article 59 of the Statute of the International Court of Justice, the decisions of the court have no binding force except as between the parties and in respect of the case under consideration. The court has striven to follow its previous judgments and insert a measure of certainty within the process, so that while the doctrine of precedent as it is known in the common law, whereby the rulings of certain courts must be followed by other courts, does not exist in international law, one still finds that states and disputes and textbook writers quote judgments of the permanent court and the International Court of Justice as authoritative decisions. The International Court of Justice itself will closely examine its previous decisions and will carefully distinguish those cases which it feels should not be applied to the problem being studied. But just as English judges, for example, create law in the process of interpreting it, so the judges of the International Court of Justice sometimes do a little more than merely determine it. One of the most outstanding instances of this occurred in the Anglo-Norwegian fisheries case, with its statement of the criteria for the recognition of baselines from which to measure the territorial sea, which was later enshrined in the 1958 Geneva Convention on the Territorial Sea and Contiguous Zone. Reiter's Article 38 includes as a subsidiary means for the determination of rules of law the teachings of the most highly qualified publicists of the various nations. Historically, of course, the influence of academic writers on the development of international law has been marked. In the heyday of natural law, it was analyses and juristic opinions that were crucial, while the role of state practice in court decisions was of less value. Writers such as Gentili, Grotius Pufendorf, Vankershuk, and Vettel were the supreme authorities of the 16th to 18th centuries that determined the scope, form, and content of international law. With the rise of positivism and the consequent emphasis upon state sovereignty, treaties and custom assumed the dominant position in the exposition of the rules of the international system, and the importance of legalistic writings began to decline. Thus, one finds that textbooks are used as a method of discovering what the law is on any particular point rather than as the founder source of actual rules. There are still some writers who have had a formative impact upon the evolution of particular laws, for example Guidel on the law of the sea, and others whose general works on international law tend to be referred to virtually as classics, for example Oppenheim and Rousseau.